I was sitting on my back porch with a cup of coffee when I noticed the construction crew tearing up my meadow. And that was the moment I realized the Pinewood Heights HOA had completely lost their minds. My name is Ryan Norwood, and I had owned this beautiful 5-acre property in Bend, Oregon for 7 years. The house sat on the front 2 acres, while the back 3 acres were a gorgeous natural meadow filled with wildflowers, native grasses, and the occasional deer that would wander through at dawn. It was the whole reason I bought the place. When I moved here from Portland, I specifically wanted space, tranquility, and distance from the cookie-cutter suburban nightmare I had escaped. The Pinewood Heights HOA was supposed to govern the main subdivision about a quarter-mile down the road. My property was technically within their jurisdiction, but barely. I paid my modest dues every year, showed up to exactly 0 meetings, and assumed they would leave me alone since I was so far from the main cluster of homes. I was wrong. "Hey!" I shouted, jumping off the porch and jogging toward the crew. There were 4 men with shovels, 2 with measuring equipment, and a small excavator already digging into the earth. "What the hell are you doing?" A guy in a yellow hard hat looked up from his clipboard. "HOA project. Dog park installation. On my property." My voice went up an octave. He looked confused and checked his paperwork. "This is the designated community space according to the work order. This is my private land, my meadow. Who authorized this?" Before he could answer, I heard the click of heels on the gravel path. Brenda Hutchins, the HOA president, was marching toward us with her signature tight-lipped smile that never reached her eyes. She was 52, had that aggressive blonde bob that seemed mandatory for women in her position, and wore a pantsuit even though it was 9 in the morning on a Saturday. "Ryan, good morning," she said in that syrupy voice that made my skin crawl. "I see you have discovered our exciting new community project. Brenda, this is my land. You cannot build anything here." She tilted her head like I was a confused child. "Actually, according to Section 47, subsection C of the HOA bylaws, any land within the Pinewood Heights boundaries can be designated for community use if it serves the greater good of the residents." I stared at her. "That is not a real thing." "It absolutely is." We had our lawyer review everything. This meadow has been sitting unused for years, and our community desperately needs a dog park. We have over 40 dogs in the neighborhood, Ryan. 40 dogs with nowhere to properly exercise and socialize. There is literally a public park 2 miles away with a dog section. That park is poorly maintained and too far for many of our elderly residents. She clasped her hands together. "This location is perfect, central, spacious, and frankly, you are not using it for anything productive." My jaw dropped. I was using it as my private property to look at, to enjoy, because it belongs to me. "The HOA disagrees with your interpretation. We took a vote at last month's meeting. It passed unanimously." "I was not at that meeting. That is not our problem. Attendance is voluntary, but decisions are binding." She gestured to the crew. "Please continue, gentlemen. Ryan, I suggest you review the bylaws. Everything we are doing is completely legal." She turned and walked away before I could formulate a response that did not involve obscenities. The construction crew, looking uncomfortable but following orders, went back to work. I stood there watching them tear into my meadow, feeling my blood pressure spike to dangerous levels. I went inside and immediately started searching for the HOA bylaws. I had a folder somewhere with all the paperwork from when I bought the house. After 20 minutes of frantic digging through filing cabinets, I found it. The bylaws were 73 pages of dense legal language that I had never bothered to read because, like a fool, I assumed they would contain reasonable things like keep your lawn mowed and do not paint your house neon pink. I searched for Section 47. It did exist, but subsection C said nothing about commandeering private property. It talked about maintenance responsibilities for shared spaces like the subdivision entrance and the small gazebo near the mailboxes. There was absolutely nothing that gave the HOA authority to take someone's land. I called my buddy Marcus, who was a real estate attorney in Portland. He did not practice HOA law specifically, but he knew more than I did. Marcus, I need help. The HOA is building on my property without permission. Slow down. What? I explained the situation while watching out my window as the excavator continued to dig. Marcus listened, asked a few questions about my deed and the bylaws, and then sighed. Ryan, they cannot do that. If you own the land outright and the deed is clear, they have no authority to build anything without your written permission. HOAs have power, but they are not governments. They cannot just seize private property. Brenda said their lawyer approved it. Then their lawyer is either incompetent or lying. You need to stop the construction immediately and get your own lawyer. Like today. I thanked him and hung up, then marched back outside. The crew had already dug several deep post holes and was unloading lumber from a truck. Stop, I said loudly. All of you need to stop right now. You are trespassing on private property and I am ordering you to leave. The foreman, the guy with the yellow hard hat, looked genuinely distressed. Sir, we are just doing the job we were hired for. The HOA paid us and provided permits. What permits? From who? He showed me a document. It was an HOA-issued work authorization signed by Brenda Hutchins. It was not a real permit from the county or any legitimate authority. It was just a piece of paper she had created. This is not a legal permit. This is something the HOA printed. You need actual county approval to do construction, and I guarantee you do not have it. The foreman looked at his crew, then back at me. Look, man, I do not want any trouble. We are just trying to make a living. The HOA said everything was cleared. They lied. I am the property owner, and I am telling you to stop. If you continue, I will call the police and report you for trespassing and property destruction. That got their attention. The foreman made a phone call, presumably to his boss, and after a heated conversation, they started packing up their equipment. It took another hour, but eventually they left, leaving behind the torn-up earth and half-dug holes as evidence of the violation. I took extensive photos and videos of everything, then called the Deschutes County Sheriff's Office to file a report. A deputy named Officer Patterson showed up around noon. He was in his 30s, professional, and actually listened to my complaint. So the HOA authorized construction on your property without your permission? He asked, taking notes. Correct. They claim they have the legal right, but I have checked my deed and the bylaws. There is nothing that gives them that authority. He walked the property line with me, confirmed the boundaries matched my survey documents, and photographed the damage. This is a civil matter primarily, but the property destruction could be criminal depending on how you want to proceed. I would recommend getting a lawyer and possibly filing for a restraining order to prevent further construction. Can you talk to the HOA? Tell them to stop. I can pay them a visit and explain the situation, but if they have their own lawyer telling them they are in the right, they might not listen. HOA disputes get messy, but I will try. Officer Patterson was good to his word. He drove over to Brenda's house, which was in the heart of the subdivision, and I heard later from a neighbor named Tom, who happened to be walking his dog, that there was a loud argument on her front lawn. Apparently Brenda insisted the HOA had every right to proceed, and Officer Patterson informed her that property owners have rights that supersede HOA rules. It did not matter. By Monday morning, the construction crew was back. I was getting ready for work when I heard the machinery fire up again. I ran outside in my work clothes and nearly lost it. Not only was the original crew there, but they had brought more people and more equipment. They were moving fast, clearly trying to get as much done as possible. "I told you to leave," I shouted. The foreman would not even look at me. "We got new instructions. The HOA says they have legal clearance and we are being paid to finish the job." I called the sheriff's office again, but they said the same thing. It was a civil matter. They could not physically remove the crew without a court order. I called Marcus again, and he gave me the name of a local attorney named Patricia Vasquez who specialized in property disputes and HOA issues. I called her office, and by some miracle, she had a cancellation and could see me that afternoon. I took a long lunch break and drove to her office in downtown Bend. Patricia was sharp, direct, and did not waste time. "They are banking on you not fighting back," she said after I explained everything. "HOAs do this more often than you would think. They overstep, claim legal authority they do not have, and hope the homeowner either does not know their rights or cannot afford to fight. The fact that they are continuing construction after you have objected is a massive problem for them. Can we stop them?" "Yes. We will file for an emergency temporary restraining order and an injunction. We will also sue for property damage, trespass, and legal fees. If we can get in front of a judge this week, we can shut this down fast. How much is this going to cost me?" She quoted me a retainer fee that made me wince, but I paid it. My Meadow was worth it. Patricia moved quickly, filing paperwork that same day. We got a court date for Thursday, just 3 days away, for the emergency hearing. In the meantime, I documented everything. I took photos every morning and evening. I measured the construction progress. They had erected fence posts, poured concrete for a small pavilion, and started installing benches. My beautiful Meadow was being turned into a suburban amenity, and there was nothing I could physically do to stop it without getting arrested myself. On Tuesday evening, Brenda showed up at my door with 2 other HOA board members, Donald Kramer, the vice president, and Linda Fellowship, the treasurer. All 3 of them had that same condescending expression. "Ryan, we need to talk," Brenda said, "through our lawyers. Get off my porch." "There is no need for hostility. We are all neighbors here." "You are destroying my property. We are way past neighborly." Donald stepped forward. He was a pudgy man in his 60s with a comb-over. "Ryan, you are being unreasonable. This dog park benefits everyone, including you. Property values will increase with better amenities." "I do not care. It is my land." Linda, a thin woman with glasses, chimed in. "We have done our due diligence. Our attorney has assured us that we are within our rights. If you continue to obstruct this project, we will have no choice but to fine you for non-compliance." I actually laughed. "You are going to fine me for not letting you steal my land. Good luck with that." "It is not stealing," Brenda said firmly. "It is community allocation. You signed the HOA agreement when you purchased your home. You agreed to abide by our rules. Show me the specific rule that says you can take my property." "It is in the bylaws." "No, it is not. I have read them. You are lying." Brenda's face went red. "We are not liars, Ryan. We are volunteers trying to improve this community, and you are standing in the way of progress because of selfish reasons. Get off my porch." They left, but not before Brenda handed me an official-looking letter. It was a notice of violation and a fine of $500 for obstruction of community projects and hostile behavior toward board members. I crumpled it up and threw it in the trash. Thursday morning arrived, and I met Patricia at the Deschutes County Courthouse. It was a modern building with high ceilings and too much natural light for the stress I was feeling. The HOA had their lawyer there too, a guy named Gregory Marsh who looked like he had stepped out of a 1980s corporate training video. Slicked back hair, expensive suit, and a briefcase that probably cost more than my first car, we went before Judge Ellen Pritchard, a woman in her late 50s with a reputation for not tolerating nonsense. Patricia presented our case first, showing photographs of my property, the deed proving ownership, and the relevant sections of the HOA bylaws that definitively did not grant them the authority to commandeer private land. Your Honor, this is a clear-cut case of trespass and property destruction, Patricia said. The HOA has no legal standing to build on my client's land. They have been asked repeatedly to stop, and they have refused. We are requesting an immediate injunction to halt all construction and an order for the HOA to restore the property to its original condition at their expense. Judge Pritchard looked at Gregory Marsh. Counselor, what is the HOA's position? Gregory stood and smiled like he was about to explain something obvious to a child. Your Honor, the Pinewood Heights HOA is acting well within its authority as outlined in the community bylaws. Section 47, subsection C clearly states that land within the HOA boundaries can be allocated for community use when it serves the collective interest. I have read the bylaws, Judge Pritchard said, flipping through a copy on her desk. Subsection C refers to shared maintenance responsibilities, not land appropriation. With respect, Your Honor, that is a narrow interpretation. The spirit of the bylaws is to allow the HOA to manage community resources effectively. Mr. Norwood's meadow has remained undeveloped and unused for years. The HOA made a democratic decision to utilize that space for the benefit of all residents. Does Mr. Norwood own the land? The judge asked. Technically, yes, but then the HOA has no right to build on it without his permission. This is not a difficult concept, Mr. Marsh. Gregory tried a different angle. Your Honor, if we halt construction now, the HOA will suffer significant financial losses. We have already invested over $20,000 in materials and labor. That is unfortunate, but it does not grant you retroactive permission to trespass, Judge Pritchard said. She looked at me. Mr. Norwood, is it your position that you never gave permission for this construction? That is correct, Your Honor. I was never asked, never consulted, and I have repeatedly told them to stop. She nodded and made some notes. I am issuing a temporary restraining order effective immediately. The HOA is to cease all construction on Mr. Norwood's property. Any equipment, materials, or structures currently on the land are to remain untouched pending a full hearing on the matter. That hearing will be scheduled for 3 weeks from today. At that time, we will determine permanent remedies, including potential restoration costs and damages. Are we clear, Mr. Marsh? Gregory looked like he had swallowed a lemon. Yes, Your Honor. We left the courthouse, and I felt a wave of relief. Patricia seemed pleased but cautious. This is a good start, but the real fight is at the full hearing. They are going to come back with more arguments, possibly expert witnesses, anything to justify what they did. We need to be prepared. Over the next 3 weeks, the HOA did not contact me directly, but I heard through the neighborhood grapevine that they were furious. Brenda apparently called an emergency meeting and ranted about entitled homeowners who did not care about the community. Several residents started taking sides. Some thought the dog park was a great idea and blamed me for being difficult. Others, particularly those who valued property rights, supported me and started questioning the HOA's overreach. Tom, the neighbor who had witnessed Officer Patterson's visit to Brenda's house, stopped by one evening with a 6-pack of beer. He was a retired mechanic in his late 60s, gruff but kind. "Heard you are fighting the good fight," he said, handing me a beer. "Trying to. They are making it difficult. Brenda has been a tyrant for years. Most of us just keep our heads down because it is easier than fighting. But this dog park thing is crazy. I own my land. You own yours. She cannot just decide to take it. Apparently, she thinks she can." Tom shook his head. "HOAs used to be about keeping the neighborhood nice. Now it is about control. Brenda loves control. Last year, she tried to fine me because my mailbox was the wrong shade of black. Not even kidding. Wrong shade. What did you do? Repainted it. Was not worth the fight. But your situation is different. If you let her get away with this, what is next? She will be annexing garages, front yards, whatever she wants." He was right. This was not just about my meadow. It was about setting a precedent. The full hearing arrived on a rainy Tuesday morning. The courtroom was more crowded this time. Several HOA board members were there, along with a handful of residents who apparently had nothing better to do. Patricia had prepared extensively, and we had our documents, photographs, and even a property surveyor who would testify if needed. Judge Pritchard entered, and we all stood. She got right to business. "We are here to determine the final disposition of the property dispute between Ryan Norwood and the Pinewood Heights HOA. Mr. Marsh, I assume you have additional arguments." Gregory stood, looking more prepared than last time. "Yes, Your Honor. We have conducted a thorough review of the situation and believe there was a mutual misunderstanding. The HOA operated under the good faith belief that the meadow in question was part of the common area, not private property." "Based on what?" Patricia interjected. "Based on historical usage and ambiguous boundary descriptions in early subdivision plans. We have brought a land surveyor who will testify that the boundaries were not clearly marked." Patricia stood. "Your Honor, Mr. Norwood's deed is unambiguous. The property lines are clearly documented, and the county records confirm his ownership. The HOA's supposed confusion is not supported by any evidence." Judge Pritchard called the HOA's surveyor to the stand. His name was Kenneth Drury, and he looked nervous. Under questioning, he admitted that the current legal description of the property was clear, and that Ryan Norwood owned the meadow. However, he suggested that older maps from the 1980s, when the subdivision was first created, showed the area as undeveloped common space. Patricia cross-examined him. "Mr. Drury, are these older maps legally binding?" "No, but they provide context. And the current deed filed with the county supersedes these older maps, correct?" "Yes." "So there is no actual ambiguity about who owns the land?" "Not legally, no." That testimony effectively collapsed the HOA's argument. Judge Pritchard looked annoyed. "Mr. Marsh, it seems your client proceeded with construction based on outdated and legally irrelevant information. That does not constitute good faith. That constitutes negligence." Gregory tried to recover. "Your Honor, the HOA acted on advice from prior counsel. We do not believe there was any malicious intent. Intent is irrelevant when the law is clear. Mr. Norwood owns the land. The HOA trespassed and caused damage. The question now is remedy." Patricia outlined our demands. Immediate removal of all structures and materials at the HOA's expense. Restoration of the meadow to its original condition. Compensation for damages, and reimbursement of legal fees. Gregory argued that the removal costs would be excessive and that the HOA could not afford it. "Your Honor, we are a small community organization run by volunteers. We do not have the budget for this." "Then you should not have built on someone else's property," Judge Pritchard said bluntly. "This is not a sympathetic situation, Mr. Marsh. Your client broke the law. They will pay the consequences. She ruled in my favor on every point. The HOA was ordered to remove all structures, restore the meadow, and pay my legal fees, which had ballooned to nearly $15,000. She gave them 30 days to complete the removal and restoration, with daily fines if they failed to comply. Brenda looked like she might have a stroke. She stood up in the gallery. "Your Honor, this is unjust. We were trying to help the community." "Sit down, Mrs. Hutchins," Judge Pritchard said coldly. "Your intentions do not excuse your actions. If you want to appeal, you are welcome to do so, but the restraining order and immediate removal order stand." We left the courthouse victorious, but I knew this was not over. HOAs do not give up easily, and people like Brenda do not handle losing well. Over the next 2 weeks, the HOA dragged their feet. They hired a removal crew, but the work was slow and half-hearted. They took down the pavilion but left the concrete foundation. They pulled up some fence posts but left others. It was clear they were stalling, hoping I would either give up or settle for a partial restoration. I documented every day of non-compliance and sent updates to Patricia. She filed a motion for contempt, and we ended up back in court. Judge Pritchard was not pleased. "Mr. Marsh, your client was given clear instructions. Why has the property not been fully restored?" "Your Honor, the restoration is complex and requires specialized contractors. We are working as quickly as possible." The deadline was 5 days ago. I am imposing the daily fines as outlined in my order. Additionally, if the property is not fully restored within 1 week, I will hold the HOA board members personally liable. That threat worked. Within 3 days, a professional restoration crew showed up and worked from dawn to dusk. They removed every trace of the dog park, hauled away all the materials, and brought in native plants and soil to repair the damage. It was not perfect, but it was close. The meadow slowly began to recover. The wildflowers would take time to fully return, but the grasses were resilient. I spent evenings out there, watching the sunset and feeling a sense of hard-won peace. But the financial fallout for the HOA was severe. The total cost, including removal, restoration, legal fees, and court fines, exceeded $60,000. The HOA had to impose a special assessment on all residents to cover it. Each household was billed an additional $300. That was when the real backlash started. Residents who had been indifferent or even supportive of the dog park turned on the HOA board. People started showing up to meetings demanding answers. How could the board have been so reckless? Why did they not verify ownership before starting construction? Who was going to be held accountable? Tom stopped by again, this time with news. Brenda resigned. So did Donald and Linda. The whole board quit. Seriously? Yep. They could not take the heat. People were calling for them to personally pay the assessment cost since it was their screw-up. They bolted before it got uglier. A new board was elected, composed of more reasonable people who had no interest in grandiose projects or power trips. One of the first things they did was issue a formal apology to me and a promise to review the bylaws to prevent future abuses. But I was not quite done. Patricia suggested we consider a lawsuit for additional damages, particularly for the stress and disruption caused. I thought about it, but ultimately decided against it. The HOA had been punished, the responsible parties were gone, and my meadow was being restored. Dragging it out further felt petty. However, there was one more twist. About a month after the restoration was completed, I received a letter from a law firm in Portland representing Brenda Hutchins personally. She was threatening to sue me for defamation, claiming I had slandered her reputation and caused her emotional distress. I called Patricia immediately. "Can she do this? She can try, but she will not win. Truth is an absolute defense against defamation, Everything you said about her was accurate and documented. This is a desperate attempt to save face." Patricia sent a strongly worded response, and Brenda's threat fizzled out. I never heard from her again. Life slowly returned to normal. The meadow continued to heal, and by the following spring it looked almost as good as before the HOA's disastrous project. The wildflowers bloomed in waves of color and the deer returned. I learned a few important lessons from the experience. First, always read the HOA bylaws before buying a property, no matter how tedious they seem. Second, HOAs have limits to their power, and those limits need to be enforced. Third, people like Brenda exist in every community, and they thrive on unchecked authority and apathy from residents. Tom and I became good friends. He would come over on weekends, and we would sit on the porch, drink beer, and complain about various things like properly curmudgeonly neighbors should. He told me stories about the old board's antics, most of which were absurd but harmless compared to what I had dealt with. One Saturday afternoon, about 6 months after the whole ordeal ended, Tom showed up with a surprise. He had brought his dog, a scruffy terrier mix named Buster. "Thought you might not mind if Buster ran around a bit," he said with a grin. "You know, since you have got all this unused space." I laughed. "Bring him in. At least this way a dog actually gets to enjoy the meadow." We walked out to the back and Buster took off, bounding through the grass with pure joy. It was the first time I had seen a dog out there, and despite everything, it made me smile. "You know," Tom said, "it is ironic. They wanted a dog park so badly and now you have got one, sort of." "Yeah, but this one comes with permission." He raised his beer. "To property rights." "To property rights," I echoed, clinking my bottle against his. The new HOA board turned out to be remarkably competent. They focused on actual maintenance issues, organized a few community events that were optional and enjoyable, and stayed out of people's business. It was what an HOA should be, a functional organization that served residents without overstepping. I did attend a few meetings after everything settled down, mostly to keep an eye on things and make sure no one got any ideas about my property again. At one meeting, a new resident suggested building a community garden on unused land. The board immediately asked, "Who owns the land?" Lesson learned. The financial impact on the community lingered for a while. That $300 special assessment annoyed a lot of people, and several families moved out because of it. Property values dipped slightly as word spread about the HOA drama, but they eventually recovered. I ran into Gregory Marsh, the HOA's lawyer, at a coffee shop in Bend about a year later. He recognized me and looked uncomfortable. "Mr. Norwood," he said, nodding. "Mr. Marsh." There was an awkward pause. For what it is worth, I told them they were making a mistake. They did not want to hear it. "Then why did you defend them in court?" "Because they were paying me. But after that case I stopped taking HOA clients. Too much hassle, too much crazy." I appreciated the honesty, even if it came too late to matter. As time went on, the whole experience became a story I would tell at parties or when people asked about my property. It always got a strong reaction. Some people were horrified, others were fascinated, and a few admitted they had their own HOA horror stories. One thing that surprised me was how many people lived in fear of their HOAs. I would hear stories about fines for trivial things, harassment over minor violations, and boards that acted like petty dictators. It made me realize how lucky I was that I fought back and won. A lot of people either could not afford to fight or were too intimidated to try. Patricia and I stayed in touch. She sent me a holiday card every year, and I referred a few people to her when they had property disputes. She told me that my case had become something of a teaching example in HOA law circles. An illustration of what happens when boards overreach without understanding the legal limits of their authority. The Meadow thrived. I started spending more time out there, sometimes bringing a chair and a book, other times just walking through and enjoying the space. It became a kind of meditation for me, a reminder that some things are worth fighting for. Tom passed away 2 years after the whole ordeal ended. Heart attack, sudden and unexpected. I missed him. He had been one of the few people who truly understood what I had gone through and supported me without hesitation. I scattered some wildflower seeds in the meadow in his memory. Buster, who Tom's daughter inherited, still visited occasionally. The Pinewood Heights HOA continued to function under new leadership, and I never had another major conflict with them. They sent me the occasional notice about dues or community events, and I paid or attended when it made sense. We coexisted peacefully, which was all I ever wanted in the first place. Looking back, I do not regret fighting the HOA, even though it was stressful, expensive, and time-consuming. If I had let them get away with it, I would have lost a piece of my property and my self-respect. More importantly, I would have set a precedent that the board could do whatever they wanted without consequences. There were moments during the legal battle when I wondered if it was worth it. When I was writing checks to Patricia, when I was spending hours documenting construction progress, when I was lying awake at night angry and anxious. But standing in my meadow, watching the wildflowers sway in the breeze, I knew I had made the right choice. The dog park that was never meant to be became a lesson for the entire community. It taught residents to pay attention to what their HOA was doing, to question authority when it overstepped, and to understand their rights as property owners. Several people thanked me over the years for standing up to the board, saying it made them more vigilant and empowered. I also learned to appreciate the legal system, flawed as it is. Judge Pritchard had been fair, decisive, and unwilling to let the HOA's excuses justify their actions. The process worked, even if it took time and money. That was reassuring in a world where justice often feels out of reach. One summer evening, about 3 years after everything ended, I was sitting on my porch when a young couple walked up the driveway. They introduced themselves as potential buyers looking at a house in the subdivision and said they had heard about my property. "We heard you had some trouble with the HOA," the woman said. "We wanted to ask about it before we commit to buying here." I appreciated their diligence and told them the whole story. They listened intently, asked good questions, and seemed thoughtful. "So the new board is better?" the man asked. "Much better. They have learned from the previous board's mistakes. But my advice is to always read the bylaws, attend at least a few meetings a year, and do not assume the HOA has your best interests at heart. They are made up of volunteers, and volunteers can have agendas." They thanked me and left. I do not know if they ended up buying in Pinewood Heights, but I hoped I had given them the information they needed to make an informed decision. The meadow continued to be my sanctuary. I never built anything on it, never tried to develop or monetize it. It remained wild and natural, exactly as I wanted it. Occasionally, people would ask why I did not do something with all that space, and I would just smile and say it was doing exactly what it was supposed to do. In the end, the HOA's illegal dog park attempt cost them far more than they ever anticipated. It cost them money, credibility, and leadership. It cost Brenda her position and reputation. And it served as a cautionary tale for anyone who thought HOAs could operate without accountability. For me, it was a hard-won victory that reinforced the importance of standing up for what is right, even when it is difficult. My meadow was more than just land. It was a principle, a boundary, and a piece of peace in an increasingly chaotic world. I never did get that dog park. But I got something better. My property, my rights, and my dignity intact. And on a warm spring morning, sitting on my porch with coffee and watching the wildflowers bloom, that felt like more than enough. The years continued to roll by peacefully after that. I refinanced my house at one point and made sure to have the property surveyed again, just to have updated records on file. The surveyor confirmed what I already knew. Every inch of that meadow was mine, legally and unambiguously. I framed a copy of the survey and hung it in my office as a reminder. The new HOA board implemented several reforms that I had to give them credit for. They created a transparency policy requiring all major decisions to be announced at least 30 days in advance with clear documentation. They also established a property rights committee that reviewed any project involving land use to ensure no one's ownership was being violated. It was exactly what should have been in place from the beginning. I became something of a local legend in Bend, at least among people who followed HOA disputes. A journalist from the Bend Bulletin reached out to me a few years after the case concluded, wanting to do a feature story on HOA overreach. I agreed to be interviewed, and the article ended up being published with the headline, "Homeowner Wins Battle Against HOA's Illegal Land Grab." It was accurate, if a bit dramatic. The article generated some interesting responses. I received emails from people as far away as California and Texas who were dealing with their own HOA nightmares. Some wanted advice, others just wanted to share their stories. I did what I could to help, usually by recommending they find a good property lawyer and document everything meticulously. One email stuck with me. It was from a woman in Florida whose HOA had tried to force her to remove a vegetable garden from her backyard, claiming it violated aesthetic standards. She had fought back, citing state laws protecting edible landscaping, and won. Her message ended with, "Thank you for showing that HOAs are not untouchable. Your story gave me the courage to fight. That made everything worthwhile. My professional life continued as normal. I worked as a software consultant, mostly remote, which meant I spent a lot of time at home." The meadow became the view I stared at during long video calls and coding sessions. It was better than any office. Occasionally, I would think about Brenda and wonder what happened to her. I heard through the grapevine that she and her husband had moved to Arizona not long after she resigned from the board. I did not wish her ill, but I also did not feel bad about how things turned out. She had made choices, and those choices had consequences. The dog park idea never completely died in the community. A few years after my case, a group of residents pooled money and worked with the county to build a small dog park on actual public land near the subdivision. It was done legally, with proper permits and on land that belonged to the county. I donated $100 to the project. I had never been against dog parks, just against them being built on my property without permission. Tom's daughter, Jennifer, became a friend. She would bring Buster over to run in the meadow, and we would talk about her dad and life in general. She was a teacher at the local high school and had inherited Tom's no-nonsense attitude. "Dad always said you were the only person in Pinewood Heights with a backbone," she told me once. "He really admired that. Your dad had plenty of backbone himself. He just picked his battles." True. But he was glad you picked that one. He talked about it all the time. Those conversations reminded me that standing up for what is right does not just affect you. It impacts the people around you, sometimes in ways you do not realize. The meadow continued to flourish. I hired an ecologist to come assess the land and give me advice on how to support the native species. She recommended reducing foot traffic in certain areas during nesting season and planting a few additional native flowers to encourage pollinators. I followed her advice, and the meadow became even more vibrant. Birds nested in the grasses, butterflies danced among the flowers, and deer continued their early morning visits. It was a small ecosystem, thriving because it had been allowed to remain wild. That would not have been possible if the HOA had paved it over for a dog park. I thought about that often. How close I had come to losing it. How easily it could have been destroyed if I had not fought back. The legal system had worked, but it had required effort, money, and persistence. Not everyone has those resources, and that bothered me. I started making small donations to legal aid organizations that helped homeowners fight HOA abuses. It was my way of paying forward the victory I had earned. If my case could serve as a precedent or provide funding for someone else's fight, then the struggle had meant even more. As I approached a decade of living on the property, I reflected on how much had changed and how much had stayed the same. The house had aged gracefully, the meadow had survived and thrived, and I had learned more about property law, community dynamics, and personal resilience than I ever expected. The Pinewood Heights HOA was now a model of reasonable governance, at least compared to what it had been under Brenda's leadership. New residents often commented on how well-run and non-intrusive the HOA was, having no idea of the drama that had led to those reforms. I never forgot, though. And I made sure that when people asked about the neighborhood, I told them the truth. It was a good place to live now, but that had not always been the case. Vigilance was necessary. HOAs could change quickly depending on who was in charge. One autumn afternoon, I was raking leaves in the front yard when a car pulled up. A woman in her 40s stepped out, looking nervous. "Are you Ryan Norwood?" she asked. "I am. I am Karen Middleton. I just moved into the neighborhood and I heard about what happened with the dog park. I wanted to ask your advice." The irony of her name was not lost on me, but she seemed genuinely concerned, not confrontational. "What is going on?" I asked. "The HOA sent me a violation notice. They are saying my fence is 6 inches too tall and I need to cut it down or face fines." "But the fence was here when I bought the house. It has been there for 15 years. I knew this tactic. HOAs sometimes enforced rules selectively, often targeting new residents who did not know their rights. "Did you get a property inspection before you bought the house?" I asked. "Yes." "And the fence was not mentioned as a violation?" "No." "Then you have a good case. The HOA cannot suddenly decide something that has existed for years is a problem. That is called selective enforcement, and it is not legal. Document everything, get a copy of your inspection report, and if they push, get a lawyer. Do not just pay the fine." She looked relieved. "Thank you. Everyone said you would know what to do." I gave her Patricia Vasquez's contact information and wished her luck. It felt good to help someone else navigate the same kind of nonsense I had dealt with. The seasons continued their cycle. Winter brought snow that blanketed the meadow in white. Spring brought the wildflowers back in full force. Summer turned the grasses golden. Autumn painted everything in warm tones before the cycle started again. I started hosting a small annual gathering in the meadow every summer. Just a few friends, some grilled food, and an afternoon of relaxation. It became a tradition, a way to celebrate the space and the fight that had preserved it. At one of these gatherings, a friend named Michael asked me if I ever regretted buying a property with an HOA. "Sometimes," I admitted, "but if I had bought elsewhere, I would not have this meadow. And I would not have learned what I am capable of when pushed." "You think you would do it again? Fight them, I mean." "Absolutely. Some things are worth fighting for," he nodded. "Most people would have just given up. Most people do not realize they have options. That is the problem." HOAs count on that. The conversation shifted to other topics, but that exchange stayed with me. I had been lucky in many ways. I had resources, I had found a good lawyer, and I had a strong case. Not everyone has those advantages. That is why sharing my story mattered. Over the years, I received occasional updates about the fallout from my case. Apparently, the legal precedent it set had been cited in other HOA disputes across Oregon and even in neighboring states. Judges referenced it when ruling on property rights issues, and lawyers used it as an example of HOA overreach. Patricia told me during one of our catch-up calls that my case had become part of a legal textbook on property law. "You are officially an example," she said with a laugh. Congratulations. It was surreal to think that my fight over a meadow in Bend, Oregon had become a teaching tool for law students. But if it helped future homeowners stand up for their rights, I was proud of that legacy. The meadow remained the heart of my property and my life. It was where I went to think, to decompress, to remember what mattered. It was proof that individuals could stand up to institutions and win, that the law could work when applied correctly, and that some things should never be compromised. As I sat on my porch one evening, watching the sun dip below the horizon and paint the sky in shades of orange and pink, I thought about everything that had happened. The anger, the stress, the legal battles, the victory, the recovery. It had been exhausting and expensive, but it had also been necessary. The meadow stretched out before me, wild and beautiful, exactly as it should be. No dog park, no pavilion, no intrusion, just nature, reclaiming and thriving. I raised my glass of whiskey in a silent toast to the fight, to the meadow, and to the principle that property rights still meant something. They had sworn it was legal. The HOA had built their dog park on my meadow, and the judge had ordered immediate removal at their cost. Justice had been served. The land had been restored, and I had learned that sometimes the only way to protect what you value is to fight for it with everything you have. And I would do it all again in a heartbeat.